Association that existed. If you go to the Queen's Museum in Calcutta, there is even a sign that says July 1882 Indian Lawyers Association meeting. So we're back after 100 years, I guess, or more. So one of the first things we want to do is we feel that the British left India 75 years ago and gave the country freedom, but the lawyers in India are still in prison to a large extent. We can't advertise, we can't take matters on a contingency basis. The poor or any nation can only afford lawyers if the lawyers are willing to work on a success fee basis. A lot of the developed nations around the world wouldn't be developed nations but for lawyers working on a contingency basis. And so we want to make our body stronger, lawyers stronger, have them, give them more opportunities to create more wealth and also serve the community. Now, deep down, the single largest passion of ILA is that we got political freedom in 1947 and economic freedom in 1991, but we feel that the next freedom of India will come from lawyers. We feel that India cannot become a first world nation till we have a first world legal system. And with 70,000 pending cases in front of the Indian Supreme Court and 49 million pending cases in the country, a quarter of them criminal matters. Average, it's taking 10 years for a criminal to get a courtroom to do a trial. That's not speedy justice in any way. 34% of all properties that were listed for sale in India were involved in some litigation or threat of litigation. And if you look at all of the rankings, global rankings around the world, India's numbers are not good. There's 193 countries in the world. In almost every index, India is beyond 100, from happiness to income to education to GDP, besides per capita income, and including the legal system. So we can't be a first world nation with not a first world legal system. So that's our inherent desire to work hand in hand with the government and the 1.4 billion people of India to become a first world nation. And we take on the responsibility, the Indian Lawyers Association, to create a good legal system. One of the things we are now planning to do is to communicate, right? To tell the government of India, people in charge, and the government of India is nothing but us people, but the people in charge of the legal department, the attorney generals and the justice department, we need to tell them what the industry body feels, that why are we behind, what's lacking, what needs to be done better, so that we can assist in becoming a first world nation. So we want to write a letter to begin with 51 points, and we're gathering these points. And today on the panel, we'll ask these esteemed board members and successful panelists of what they think needs to be fixed in the Indian legal system. We understand we're a relatively new country and a lot has been done, but a lot needs to be done. So let's talk about what needs to be done. We start with you, Prachi. You just took on the presidency of one of ILA's biggest chapters in New Delhi. So if you had a magic wand and you could fix 3 things in the Indian legal system, what would those 3 things be?
Yeah, I think I'm going to start, first of all, good morning, everyone. And I'm just going to start with a cliche that justice delayed is justice denied. And the way the discussion has started, it is established that I think the most, the biggest problem in this country and in the current legal system is the pendency of cases. And imagine there are almost 5 crore pending cases in India. There are almost 500,000 under trial prisoners which are currently there. And a lot of them have already served the sentence which they would have if they actually got a trial on time. So these are the kind of figures we are dealing with. Almost 30% of vacancies in all the high courts, it's there. So I think the first problem is that if the pendency is there and there is vacancy of judges, then it's basic common sense that we must have more judges. We must fill those vacancies. In fact, as of now, even the sanction strength of judges in India is not sufficient if you compare it to developed nations like UK or US. But we are not even able to fill that sanction strength. So I think the first suggestion would be that we have to fill that vacancy. And this is only High Court right now I have the figures for, but I'm sure it's probably even worse in district courts. And we know there's vacancy in Supreme Court as well. So we have to, I think that's going to be, if something like that happens, and it is definitely the need of the hour, it's going to be a big help in actually dealing with these pendency of cases. And especially with, so many national law schools in the country, it's not like we don't have that kind of knowledge pool or efficient people in the country which can, go on and make judges, because now there's so many law schools and so many law students, and the quality of education is also good. So that would be my first suggestion. And my second suggestion would be that, now the longevity of life has increased. So we need to also increase the retirement age of judges. Like right now for trial court, it's 60, for High Court, it's 62. And for Supreme Court, it's 65, where, there are people who are working till at least 80 and beyond these days. So I don't see a reason why why they should not rethink about the retirement age of judges. And third, I think where we are already heading is like technology. I mean, the one thing, the silver lining which came out of the pandemic was that everyone had to sort of revamp their systems and ensure that, there's some development of technology and, there's work from home. So now at least a lot of these courts have that system. The judges are using electronic files, which is much quicker. We don't have to store those number of files, which ultimately get rotten. So, there is a technology boom which is happening amongst the legal system, and of course across the world. I think we just need to keep at it and make sure that we are, going with the times on that as well. And if it
And
can,
a lot of judges,
yeah.
And a lot of judges are retiring and doing a second, third career after 62.
Exactly. So these would be my top 3 suggestions. And of course,
Okay.
there are many ways we can improve the legal system in India.
Okay, beautiful. And feel free to jump in when asking others. Let's make it interactive. And a little bit like Indian TV where you start screaming and interrupt. A privilege for me to welcome our new board member, Anish Mehta. He's an engineer by profession, turned lawyer, and a very successful lawyer. He did his engineering degree from University of Florida and law school from Temple. He very active in bar associations. He was a president in Philadelphia Bar. He was president of, most of you know that the predecessor of Indian Lawyers Association in India was an Indian Lawyers Association in United States with 29 chapters. All 29 do a great job running independently, have hundreds of events. And then the National Association, the South Asian Bar Association of North America, which quote unquote manages these 29 chapters. And Anish was president of the national chapter. He worked at Microsoft in India for about 7-8 years and now is in India. As soon as I found out he's transferring to India, I told him, hey, you have to get involved in ILA, and he very happily acknowledged. So what I like about engineers, Anish, is that you guys have a mental thought process that, okay, if this thing is broken, this is how you fix it. And you're an engineer and you're a lawyer, and now you've seen the legal system of other foreign countries and you've seen the legal system of India. Put on your engineering hat and tell me three things you would do to tighten up the screws.
So thank you for the introduction, Navneet. So my view is obviously from somebody who spent a lot less time practicing or living in India than the rest of you. And I'll give you my impressions after being here a year. I think the first thing that's immediate is somebody coming in, working for a multinational corporation, is that like I'm trying to figure out who the outside counsel I should be using, what the legal scene looks like out here. And sort of the best phrase I'd heard around networking, in the US was that you need to know them before you need them. And I think that's part of one of the challenges is like, I'd never practiced in the UK, but we've all heard the names of all the Magic Circle firms. I only practice in 2 cities in the US, but we know all across the country which the firms are. And that is because they're allowed to market and promote themselves in a way. And so I think it would be great if there was a way to find out how we could get the names of Indian law firms and lawyers a little bit more prominently out there so that we know who to use. It's in fact one of the biggest things that happens in my role out here is people from the US ask me who they can use out here. So I think that's number one. I mean, I think the number two, Prachi hit on the nail on the head, technology. And it's not that the technology isn't here, it's quite advanced here. It's that there's a reluctance to use it in some places. So there are times where a wet signature is required, where I think, now I think we're very well accepting of digital signatures in almost every aspect of life. So, getting that actually speeds up a lot of things, right? Not having to wait for somebody to sign something and send it in on a green form. I think there's a reliance in many areas of in-person attendance to hand in this paperwork as well. So not only does it need to be on physical paper, you might need to travel to a location and be there when it's open. So I think adopting technology in a thoughtful way, I think can speed up a lot of the processes. I think that the third one is also the same thing Prachi said. It's the dependency of cases is challenged because I think there's no predictability, right? And I think we don't necessarily need predictability in outcome, but we need predictability in timeline and process. And really those are sort of the three things I think. I mean, walking into any situation and not knowing if it's going to be resolved in 2 months or 10 years or even decades, I think causes a lot of uncertainty. And I think there can also be hesitancy for outsiders to get involved in the process, because if you don't know it, you don't know if it's fair or unfair or just like long for everybody, right? I think those are my 3 main things to think of. So technology, pendency, and really being able to market your services.
Good, thank you. We'll come back to you. CJ, so you practice a lot of criminal law, and I think delayed justice in civil matters is bad, but criminal matters is worse, because you put not only just one person's life on hold, but maybe that whole family's life on hold. And like Prachi said, most of these people, had they just pled guilty on day one, they would have served their time and would have been out. And now they're waiting for trial. And somebody, maybe the smartest human being on the planet, said, and it's now commonplace and we don't even know who said it first, but there is no problem in this world. The only problem is not finding a solution. A few days ago, I was talking to a very famous judge in Jaipur, and he's probably the most hardworking judge in the country, works weekends, works on holidays, takes files home, says he has 150 cases every day. He does not like taking the bench till he's read. And he says, you know how much Indian lawyers write, 50 pages petitions. And I told him, I said, every court in around the world, in developed nations, the courts have page limits. This appeals court in California has a word limit of 70,000 words. And after you prepare the appeal, you have to certify that I've gone over the appeal and it does not have more than 70,000 words, and you sign it. And if the appeals court, by the way, ever checks and there's more than 70,000 words, they are going to send the pleading back. And maybe you've lost the appeal because now you don't have time to fix it. So, and I told the judge in Jaipur, I said, why do you have 50 pages for everything? Why don't you have a court limit at 10 pages, 15 pages? And I told him the limits in some other courts. And he says to me, can you send me a piece of paper? I'm like, we're the oldest civilization in the world. We were the #1 country, richest country in the world from year 1 to 1750. And now you need a foreign country's court rules to limit pages to 15. Why don't you don't need to be a scientist or an engineer. Just get together and fix it and say, don't write 50 pages. There's nothing that you can write in 50 pages that you cannot finish in 10. There's nothing. So I'm asking you, CJ, that if we put on the hat that there is no problem in this world, the only problem is not finding a solution. Countries like United States, 96% of criminal matters get resolved on plea bargaining. And we don't have that in India. How difficult is that to take on?
I have already given my view on plea bargaining in the last 2 sessions in which I have participated. Today, at the cost of repetition, I would again tell that plea bargaining is not a methodology which is going to work in India, because there is a lot of trust issues between the accused, between the defense party and the prosecution party. What is promised is not delivered. So there is always an apprehension by the person who pleads guilty, or his lawyer will never advise him to plead guilty because of this wide rift of trust issue. That is one thing. Another thing is the concept of plea bargaining as is accepted in the Western world is not possible in India for a second reason, that in India, the level of education and what you call the literacy is much lower. Even amongst the educated class, the general common sense about the legal rights, the fundamental rights of an individual is much low. America has only 7 articles, and the last amendment was done to the American Constitution in somewhere in 1997. India has, I don't know how many articles exactly, but around more than 370 articles we have in India, and so many amendments. And it makes our constitution such a complicated document that even lawyers themselves, there cannot be a consensus on what a particular article says. And even the biggest benches of the Supreme Court get divided in their views on each and every article. If the basic law of the country is so confusing, then the plea bargaining thing, I don't think that it is going to help us in any way. This view of mine may be a little prejudicial, I do not know. But as per my limited knowledge about the subject, plea bargaining, this is the reason why plea bargaining cannot work here. Secondly, you were talking about the number of pages. I fully agree with you. I have been teaching drafting and pleading in various law colleges since the last 9 to 10 years. And my stress is upon the briefest of writings. Brevity will give you more marks. Even when I'm assessing the papers, the shortest answers get equal marks as the best well-explained answers also. Once I understand the student has understood the concept in a 4-line answer, I give him 4 marks, give him or her. And you're right, brevity is of great importance. It is a great factor in the piling up of cases before the courts. And one correction here, I have a balance of both civil, criminal, as well as corporate cases. being an academician, I have always tried to explain my students that criminal and civil liabilities do not exist independently. They are coexisting. And unless there is a civil liability, which is the root cause, there cannot be a criminal manifestation. This is what is true in most of the cases. So,
Compared to the rest of the panelists, you're doing more criminal work is why I picked on you. Uh, uh, I had one judge once tell me, CJ, and you're going to love this. I said to him, hey, how come you don't do plea bargaining? He says, because the lawyers don't want to settle cases because they don't have a lot of work. So then they don't want to plea bargain and get the case over with. And I said, I don't believe that, but I don't know. Do you think it's some of that?
plea bargaining. When I draft legal notices, my legal notices are also shorter than the usual ones. But I've seen the clients when I charge, my fees is not less because the size of my notice is small. They want the notices to be long enough. I said I can't write longer. And if I am to advise a client what is right, and I don't mind if the client goes back, but I see to it that he takes my advice straightly or just change the lawyer. There might be lawyers who are holding this belief that if the case comes to an end so soon, then it will be a loss for them. As far as I'm concerned, if I am getting disposals of 4 to 5 cases, then I am free to accept 10 cases more. So my presence in a variety of cases is more manifest than my presence in the same old case.
Right. So I told this judge who was complaining that Indian lawyers write a lot and 150 cases he has every day and he has to read these 50-page petitions. So I told him, why don't you dump these 50 pages in ChatGPT and ask for a 5-page summary?
Not only lawyers who draft like this, we have judgments of the highest courts. And given the copy paste mechanism of today's, they simply give the citation and tell them to copy this para to this para and paste it. Ultimate dictation will be a few introductory part and a few conclusive part. And the middle portion of the judgment is filled up with all previous decisions, which is not required. Why does the common man need all this explanation? When the Supreme Court is passing an order, it need not give such a long explanation of previous judgments and all. Lower court, yes, because that judge's order is going to be appealed in the superior court. So he has to give all his explanations so that the higher court does not pass any strictures. But when a judgment is passed by the highest court, it should be brief to the point, and the ratio should be identified from the number of paragraphs which have been just dumped into the judgment. The common man should understand where is justice lying in these many number of lines.
Right. Collectively, I think we're wasting $1 billion of GDP in all this extra writing and reading and comprehension, and then wasting paper.
More wastage is cost to the brain cells. Unnecessary things we are reading and wasting our time.
So Sania, you're probably the most educated person in the planet. You've studied at wonderful high schools and junior schools, and in Bihar, and at Penn State in Pennsylvania, and University of Leeds in London, and National University in Delhi. My goodness. And now teaching at Jindal Global School. So I guess you should have answers to all the problems of the Indian legal system. So what's your solution?
Hi, everyone. Good morning. So I think, first of all, I think that the most, and this also goes to the very recent news that dropped on all of us yesterday itself. There are being many amendments in the existing laws, and recently there has been a bill that's going to be tabled before the parliament for changing the whole major criminal laws, IPC, CRPC, and Evidence Act. So this constant change that we are facing, every now and then as law fraternity, this is really difficult to adapt to. And because if anyone has got a chance to go through the new bill, you can really see that the sections have also changed. So that's all over. The change itself is causing a havoc amongst the law fraternity, and not to mention the academicians and students as well. So that's one thing we can slow down the pace of constant amendments that we are that's being thrown upon us. That's one thing. Second, freedom to advocate. It's something which I also taught in when I was teaching the professional ethics class. I also had a discussion and debate amongst my students with regard to what level of freedom advocates should be given. And they all of them, most of them, were in favor of allowing advocates to advertise. And some of them also gave suggestions for having a benchmark for setting minimum fees for advocates, and what should be the criteria for setting this minimum fees and maximum fees. Minimum because of the cutthroat competition that we have. Some of the advocates don't even get near to what the established advocates get, and maximum because many of the advocates just charge exorbitantly, and that makes it difficult for common people to approach those advocates. And third, a very important reform that I would suggest is regarding digitization, and making sure that this digitization is happening not just in the metropolitan cities, but also in the non-metropolitan cities. I come from Gaya, which is a very small town in Bihar. And in our place, we still haven't been able to digitize the courts fully, which means which also has a lot to do with the advocates that we have in our city courts. Most of the advocates do not know how to access computers, and then that leads to this problem, which aggravates the problem for new generation advocates, because we don't have things in digital format, and that is why we have to go to the court to access those. And many a times we don't even get the copies, because most of the copies are now somewhere thrown in the piles, and it's not even accessible. We lose a lot of copies as well, talking about their civil code. So that is the third reform that I would suggest, a full and uniform digitization of the records.
Wonderful. Thank you so much. Gagan, are you on the call?
Mr. Chug, if you don't mind, may I contribute a couple of points?
Yes, absolutely, Agastya. You're next.
Hi. Yes. So I'm an associate at Solomon and Company. I practice in Mumbai, litigation. And I had 3-4 suggestions. So since today's meeting is primarily pertaining to certain representations that may be made to the government, I think the first thing, and there are 3 or 4 points pertaining to the government. First is that the government is the biggest litigator of this country. And I'm not reinventing the wheel here when I'm making these suggestions. These have been made before. The first problem is that every time the government is involved in any sort of litigation, and an adverse order is passed against them, they will immediately appeal. And they will take this appeal all the way to the Supreme Court, fight tooth and nail, because there is a trust deficit that if they accept a final order of the court, then one of them will be accused of corruption. And this concept, this idea needs to change, because, and from the top down, if there are certain directions given to law officers, then this will change, because this really clogs up the court. If every appeal, if there are too many frivolous appeals filed by the government, who is already the biggest litigator, that's not going to help the system be more efficient. So that's number one. And consequently, the government needs to ensure that whether it's the Kane arbitration or the Vodafone arbitration or so many cases, that the government accepts awards, no matter whether it's for it, against it, accepts judgments and does not frivolously appeal them. So this is one important thing. Second is government panel lawyers. A lot of times I have seen that lawyers who join the panel of the government, they are paid per hearing. So what they will do is they will take a brief, and then because they get, let's say, 10,000 per hearing or 20,000 per hearing, then they will keep adjourning the matter and pocketing the 10,000 or 20,000 and not really ensuring the completion of litigation. So the incentives that the government offers to its panel lawyers need to be based on completion of litigation rather than per appearance hearings. I think this would go a long way. Thirdly, when it comes to our criminal justice system, I think one very important recommendation that we need to the government is when the police investigates a matter and files a charge sheet. I think we see routinely the charge sheets are thousands of pages, sometimes tens of thousands of pages for lawyers to then read, judges to then read. Then it goes into appeal. This clogs this. I mean, when we are discussing page limits for 50 pages, I think we really need to look into charge sheets that go into tens of thousands of pages. And this needs to be enforced very, very strictly. Then I feel that somewhere we need to make amendments to either the Code of Civil Procedure or High Court judges can make it themselves, wherein we need to incorporate something along the lines of a red fern hunter schedule to quicken the process of litigation. I think Delhi High Court has already gone on that path to some extent, and you see generally very good judgments in commercial matters coming out of the Delhi High Court, and also the speed at which they come out. And other courts across the country need to take a cue from that and speed up a resolution of disputes. So I think these suggestions, if we can include, this will go a long way. Just also, if I may add my 2 cents on advertisements and capping of fees, I think both of them are very well intentioned. But with respect to advertisement, before we allow everyone to advertise, we need to regulate it or ensure as to how we are going to ensure the advertising. What I mean by this is that today there are these 3, 4, 5 very big firms in India. And if you give, if you just open the floodgates and allow advertisements, what is going to happen is the big 4, 5, 6 law firms in India are going to pool in their resources, which they have in abundance. They're going to advertise a lot, and they're going to get a lot of the business that comes out of this advertisement. And the people that we really want to help, the smaller advocates, by allowing this advertising, they're not going to reap the benefits. So that's number one. Similarly, capping of fees is generally done by a lot of senior advocates, not because they want to charge exorbitant fees and not represent poor people. The reason why they do this is because a lot of rich people approach them and they want to filter out their work in some way. So I think it would be better if maybe the government passes some sort of a regulation that senior advocates have to do a certain number of pro bono matters every year, because that is the intention why you want to cap the fees, so that they represent people who don't have the money. What will happen if you cap the fees is that they will still represent rich clients who can pay that maximum fees, but they may not necessarily represent as many pro bono clients. So I think if we are giving these suggestions be given with those caveats. That's about it.
Right. So, Agastya, wonderful suggestions. All of them will be included in the letter. I have good news for you. World over, research has shown that when lawyers are allowed to advertise, the richest, biggest law firms of that country do not advertise at all. Because by advertising in Times of India and on Facebook is not the kind of clients the big firms want. And so no big firm will ever advertise. For instance, in UK or US or Australia, the top 100 firms, you will not see a single ad. What will help the smaller lawyers, the lawyers that are solo practitioners or in small practices, what will help them the most is the advertisement and allowing lawyers to take matters on a contingency basis. If one tiny thing is done in India, it'll dramatically change the entire outlook of India if lawyers are allowed to work on a contingency basis. Because I think there's so much wrong happening to so many people in India, wage theft being probably 25%, in some studies I've seen of economists, 25% of the total wages that should be paid are not being paid. And big firms don't want to do all this stuff. It's the small lawyers that benefit from advertisements. But you bring up an interesting point of senior advocates. And let me go to Dr. Methi. If he's still on the call, he's president of our ILA Rajasthan. There he is. So Dr. Methi, this creature or a special class of lawyers called senior advocates, it's the government that's branding a group of lawyers senior advocates, right? So much for the Constitution where every human being is equal, and the government should be making sure that nobody is branded in a special way and every human being is treated equally. And it's now an arm of the government that's taking a group of lawyers and branding them special advocates. This doesn't exist in the Western developed world. And a young lawyer who's a brilliant lawyer and maybe the smartest lawyer in the country and is age 28 is now doesn't get the same treatment as a senior advocate does. So isn't this violation of the Constitution to brand some lawyers as senior advocates?
Thanks, Namnesh sir. Am I audible?
Yes.
Yes. So sometimes we have to recognize the knowledge and experiences, both of them. The people acquired the experiences and knowledge during their journey of advocacy or life. First one question is that one. If there is any, what we can say, nexus or manipulation is entered in that one, that causes a problem for that. I have met so many senior advocates, or I have interact with them. So the thing is that one, equality is just like a hypothetical situation. So many times I have seen in the society, not for advocacy, in another profession also. So in my opinion, your question or your point is to be considered in a perfect manner. I have seen some young advocates, they have their vibrations and their energy and their knowledge, and they should be recognized in that one manner. So it is a time to think about that one. Only seniority is a criteria of just like that, making any advocate in as a senior advocate or anything else. Second one thing is that when I'm not aware about that one, in worldwide, what is the situation of that one? There is any bifurcation of senior advocate or a designated senior advocate or not? Just you told about that one. That is not in UK and US. Am I right, sir?
Yes. No such thing. Because good lawyers shine in their own ways.
Yes.
And I don't have a problem with Indian Lawyers Association or an industry body or Facebook or Microsoft or Times of India printing a list of the best lawyers in the country. But for the government to take a group of lawyers and make them brand them as senior advocates, that to me is massive discrimination being conducted by the government of India.
Absolutely, I agree with you. This practice should be stopped. Stop that one. Just like you telling that one, those who have a knowledge, they self-illuminated their self. We can see some young advocates also when they are in trial, or I have seen so many times in High Court. So I'm agree with you. Okay, this thing or this practice should be pondered again, and some corrective measures should be taken on this one.
So, what other solutions do you have, Dr. Methi, to fix the legal system? What should go in the letter?
For particular this one, or just like
in the entire legal system?
Just like that, yesterday we have seen three, the colonization to decolonization. First thing is that one. Just like that, nowadays I am discussing, or we are running a study circle. So we are going through the Evidence Act and CRPC in that one. We develop all the laws with the mindset of colonized mindset. Nowadays, government is taking, or law commission has taken so many steps to convert that one decolonization. Yesterday, that bill was tabled. We haven't explored yet. Previous speaker also spoke about that one number of judges, less number of judges. And one major issue raised by someone about the government advocates. In CRPC section 24 and 25, there is a particular provision about that one. The public prosecutor comes from their cadre, but political parties to give a space to their karyakartas or their followers, and they make them to the public prosecutor. So that is also creating a mash. I have seen so many places during my journey of learning. And day before yesterday, we were sitting with them. They tried to enlarge the duration of trial. I think that someone told previously mine, they put the tactics at there. So instead of that one, the cadre should become, the government's views should be put before the court by a particular cadre. And CRPC is also that present CRPC is telling about that one. But that practice is not adopted by in India particularly. Or third one thing is that one, there should be some specialization. So a dual degree concept can be evolved. A person who is law with psychology, law with IT or something else. So that also can be exploring, or a trial can be in a proper manner. And that is my submission about this one. Over to Chuk, sir.
Okay.
Mr. Chuk, if I am interrupting,
Yeah.
I would like to have 3 minutes each on advertisement, fees cap, and senior advocate, if the time permits. There are certain fundamental misunderstandings with respect to these three concepts, which I have been observing since the last 2-3 sessions.
Okay.
There are certain.
I'll come back to you in
yes,
2
yes,
minutes.
yes.
I have Jermaine and NPS Hira and Swapnil Vyas on the queue, and then it come back to you, CJ, for sure. So Jermaine, thank you for joining us. You're a partner at Solomon and Company. You work with our friend Aaron, who is going to be our president of ILA next year. So if you had a magic wand, what would you do to fix the legal system in India?
Jermaine, are you here? She lost connection, sir.
Okay. So, Mr. Hira, are you there? Okay. Swapnil? These people are on the queue. All right, CJ, while we find them, go ahead. What's your comment about senior advocates?
The comment on senior advocates is, the institution of senior advocacy was introduced to enable the courts to have a reliable person from whom a court can have an opinion on a random matter which they are hearing. Senior advocates do not have all the privileges which other advocates have. Senior advocate cannot interact with any client. That is the first restriction. Second restriction is senior advocate cannot take fees from any client.
Isn't that restraint of trade of Article 19?
No.
No,
It's
Article
not.
19
It's
says
not.
there shall not be a restraint on trade. Why are you stopping somebody from seeing a client?
To understand that, we should know the concept of advocacy as understood in India. An advocate is considered as an officer of the court. In the system of justice, it's the tripartite job of a judge and the prosecution and the defense lawyer to seek justice. The duty of the prosecution lawyer is to put forth only the prosecution case. He has to prove the case of the prosecution beyond reasonable doubt, and the defense lawyer's job is to show a lacuna or to point out doubts in the prosecution story.
Understood, but the government
and
shouldn't stop any human being
no,
from.
let me come to it. So therefore, the judges here are enabled to see both the sides of a case with the help of these
Perfect.
two advocates. Therefore, the advocates are called officers of the court.
Right. Throughout
And
the world, it's that.
yes,
Officers of
and
the court.
and that is the basics because of which there is restriction on advertisement in India. Now, the second reason why there is restriction on advertisement is for the purpose of informed consent of the consumers. In educated countries like US and the UK, where the law is enacted in the mother tongue of the people there, unlike in India, where the bill is proposed in the parliament in English, the MPs get to argue for or against the bill on the translated version of the bill, which is in English.
So you're saying that lawyers should advertise in local languages so that people come to know law.
No,
So
not that.
so you're
No.
advocating for advertising so that
No,
lawyers
not
can
that.
educate the public in their own language.
Yes, that duty is cast on the lawyers to create awareness about the law.
Right,
Now,
but they're
today,
not allowed to advertise.
In India, if you see, there's a majority of lawyers who are actually ignorant about the law. Because this is the reason why the Bar Council of India has now come up with special All India Bar examination tests and all. And even that is sought to be defeated by creating ready-made notes to how to crack All India Bar exams. So there is a general ignorance in this fraternity. So that is the reason
Okay,
why.
so one of the things we should point out to the law minister is to improve the legal education of lawyers in the country.
Yes.
Like how?
They should ban ready-made notes being available to the law students.
It's freedom of speech.
No, it's not freedom of speech.
Why do we want to ban everything? Why do we want to curtail everything? Why do we want to cap fees? Why can't it let be a free system operate? Make exams harder. Why do you want to cap? You can never ban making of notes in any country.
Yeah.
Right?
Mr. Chuk, you have not seen the quality of notes which are sold outside.
I took the Indian bar exam.
Yes.
I was told you can take one copy, one book. I took one book, I put it under my chair, and somebody stole my book.
No, I'm not talking about the bar exam notes. I'm talking about the law notes which are available for the college students. Absolutely crap.
They're available throughout the world. The standard is different. In India, there is no body to check what kind of notes are produced for the consumption of law students. There's no body to check notes anywhere in the world. It's a free world, right? Okay.
There is body.
Wonderful conversation. Agastya has 30 seconds for senior advocates. Go ahead, Agastya.
Yes, Mr. Methi had put forth that in the Western world, that is US and UK, there's no concept of a senior advocate. Just a slight correction there, or just a different perspective. There is a concept. Yeah, in UK, there's a concept of the King's Council and Queen Council, wherein they call it wearing of the silk. And that's a very, very similar concept and we have borrowed it from there in India. That's
right.
all.
But I think the solicitor barrister drama in UK is quite weakened. It does not exist in US at all. It can't exist in the US because if any court or any government or any 50 states even tries to utter a word that this lawyer is special, they will get a lawsuit in a minute, because what the Indian government or whoever is doing it and branding a group of people senior advocates is absolutely unconstitutional. Okay, Mr. Hira. Swapnil, are you ready? Madhura tells me you're ready wherever you are, Swapnil and Mr. Hira.
Swapnil, are you here? No, he also dropped off. He sent a message he wants to speak.
Mr. Chuk, I have a couple of other suggestions as well in case. Yes. So one, and this is not pertaining to the delays in litigation, but definitely something which I would call the legacy of a colonial hangover, is that even today when we go to courts, uh, firstly, there are two sets of lawyers now that are developing. First are those sets of lawyers who've taken the bar exam and appear before courts. Secondly, those lawyers who work in law firms who don't take the bar exam and therefore are not registered anywhere as such and work in firms. There's no requirement that they have to take the bar exam. So I think this sort of distinction that's being created, either remove the bar exam altogether and remove such a distinction, or mandate it for everyone. I think that is important to not have this distinction.
What about this third set of lawyers? I don't know if you can see.
No,
45% of lawyers have fake law degrees in India. What about this?
That's a separate problem. I agree that it's a very, very serious problem because they are essentially lawyer quacks. But this is a separate problem that I'm raising. It's about genuine lawyers, but who don't need to take the bar exam and are not registered anywhere. That's one issue. The second issue is that when we go to courts, we still have to have a particular dress code wherein it has to be all black, black and white, and then of course the black gown. Now, this is to some extent followed in the UK, but in most of the rest of the world, including the US, this is not a system. And for the, when with respect to India as well, it's not something that's particularly convenient because we have our monsoons are very, very different. It becomes a huge challenge in the monsoons, and our summers are very, very different and much hotter, and thus are very, very different. So I think and our law codes don't mandate either coats or gowns. So I think to some extent, if we can amend the rules somehow to fit Indian requirements, that would be very useful for lawyers.
One of the things that's very funny is that we don't let our states make independent decisions.
Oh.
And if we did, it would be nice if one court decided that you don't have to wear based on the weather in Kerala or whatever. And we don't give the freedom. And as a result, we're not seeing any new ideas and innovations coming up in one state that the other states can copy. So we have 3 minutes left, and I'll give these 3 minutes to our first two panelists, Anish and Prachi, for closing remarks and any other comments based on what others have said. Anish?
Yeah, I mean, I think this has been super helpful for me again as somebody just learning about the system, and I thought the points made about pro bono were actually interesting, and it's a thing that I'm kind of interested in learning more about, sort of what the pro bono culture is and what sort of pro bono environment is in India, because I agree. I mean, I think that's something that was near and dear to the work I got to do in the US, and certainly would like to see more pro bono opportunities in India.
Awesome. Prachi?
I think I will also agree. I think one of my favorite points is that since the senior counsels are charging a very, very high fee from people who actually can afford it, then maybe it would be a good way for them to increase the number of pro bono cases. So I think that's a really good point. I also like the point of having simpler judgments and having brief judgments which are capturing the crux and the ratio of the judgment in a manner that maybe a layman can still understand as to what is the law and what is the interpretation of the law to some extent, because a lot of the judgments are really complicated, even sometimes for us to understand as to what exactly is the final outcome. So these 2 points I thought were really good. And again, marketing and advertising and having Indian lawyers directory, I mean, that is something which is something also like a good idea, because I understand that and a lot of times not everyone has access to conferences and doing sponsorships and, going for awards and all of those things. And there is sponsorship involved at all of these events. So how, and at the same time, we don't have a right to, advertise and solicit business. And also it is a big challenge for somebody who's, starting afresh and, who doesn't have all those means to advertise. So I think all really great suggestions. And I think I agree with all of those points. Nothing further to add as such. Yeah.
Okay. We have a minute, so we'll give this to Vivek Mapari. He's
Okay.
worked in the IT world all his life, lawyer from Pune. Vivek?
Yeah, good afternoon, rather good morning, good afternoon, just in middle of both the sessions. Just a quick point, this is from the perspective of the e-filing initiatives that have recently been started at the district level. I'm purely speaking from the district perspective in this particular case right now. The three things which are very strongly to be suggested, this may be at the level of the ministry or at the state level. First is there's a very big lack of training among the staff in using this particular e-filing systems which is there right now. Second most important thing is digitization of the records. The existing case records is one of the most prime factors that would speed up the justice system. All the paper documents, if they are digitized and scanned and fed into the systems, the e-filing system is going to be tremendously helpful for the litigants, for the courts, for the staff, and in overall speeding up the justice delivery system. Third most important part is the system which is currently being designed has very high level of lacunas, and there is a very low level of interaction between the problems faced at the user level and the designer team. If all these points can be please added to the list of suggestions, it will really help at a ground level to make the system efficient and make it very, very enforceable for all the concerned parties, including the advocates, the litigants, and judges, as well as the staffing of the court system. Thank you for giving me this opportunity.
Thank you, Vivek. And if you have, seems like you have more thoughts, and so please send them to us. And you worked in the IT industry a long time, so that'll help. Because I think
Look, I have one more point, and I don't think anyone brought it up, but I think there is also we need like a reform in also the way the judges are being transferred and elevated. I think that's also like a big debate, and I know we are at the end of the discussion, so we can probably have a separate session on that topic itself.
you mean they should not be transferred every 3 years?
No, not. I think there needs to be a more transparent system. Right now, there is. It seems like there's lack of clarity. There are requests which are pending for elevation of judges, transfer of judges. I think that system is also being delayed a lot.
Right.
So,
Yes.
yeah, I just wanted to throw in that as well. Yeah.
Okay, perfect timing. We were going to end, but obviously we can't end because Honorable Justice Vineet Kothari has joined us. So welcome, Mr. Honorable Judge Kothari. We'd love to hear your comments on the letter we're writing to the Law Minister.
Yeah. Host has to unmute me.
Sir, we can hear you. We can hear you, sir.
Okay, still. Okay, then very good. I'm sorry, first of all, for joining late. I was at another conference in Bangalore. So I listened for last 5-10 minutes, but it's good. And my bit of information and contribution I would like to make to this August gathering and ILA is that in India particularly, we find government litigation to a very large extent, either by the government or against the government. So the inaction or the wrong actions or wrong orders are the major source of litigation in India, and overburdened courts are there. So some kind of law, I think, has to be brought, because there has always been a good faith clause in favor of the authorities or adjudicating authorities who pass the orders, that they cannot be questioned about the reasons for passing such orders. cryptic orders or without compliance with natural justice or things like that. So some kind of law is required to be brought for disciplining, I would say, the authorities who pass these orders, so that the government litigation, which is said to be about 70% of the bulk in the courts, right from bottom to the top, even in Supreme Court. So that should be reduced, and that can offload the burden of the court system, at least in India, I understand, to a large extent. And for that, I think ILA can, in its representation or memorandum which we prepare, give a suggestion to the government to do something about this, because what they have done so far is the litigation policy not to file cases or withdraw cases over a particular monetary limits, like in Income Tax Act. Nothing above 1 crore tax limit, tax incidents will go to the High Court, 10 crores for Supreme Court, things like that. That's not enough. But the thing required to be done is that the training kind of thing, which we like judges and lawyers have, continuing legal education is required even for the government adjudicating authorities. I have taken some lectures in NJ Bhopal for authorities of SEBI and other institutions like that. So DRT and all these. So they are also not very well versed with the how to comply with the like simple thing, principles of natural justice, audio alteram partem, giving opportunity of hearings, etc., etc. These are very small things. So they need to have a bent of mind and things like that. That what good order, reasoned order means to the judicial system in the country. And if they can do it, I think to a large extent we'll be benefited, and organization like ours can definitely give those kind of inputs to the concerned and powers that be in the system. That's my input for today. Thank you so much.
Do you think when the government is purposefully delaying matters or doing unnecessary litigation or unnecessary appeals, do you think the judges have a power to issue sanctions against the government?
Yes, sir. Actually, that will be more like a kind of punishment, because I know for sure, because I was the judge in that court in Karnataka High Court itself. I imposed 50,000 rupees cost on the commissioner merely because he did not apply his mind, gave the reasons for filing an appeal under the Income Tax Act 260A section, which lies only on the substantial question of law. I said a thing which is straight away covered by preceding judgments, precedents. How can you file again and again the same kinds of appeals? So that was a kind of punitive measure. We can't depend upon the punitive measures. What we should
And did
depend
they pay
on,
the 50,000 or did they file another appeal?
I ensured that he pays from his own pocket and not from the government money.
Oh, okay, wonderful.
That much of discipline I could bring at least one or two of the authorities of the income tax department. But that is not neither enough nor very desirable also. So
how do you prevent the government from not settling or not finishing up cases?
Yeah, I said in the order that he'll be paying from his personal pocket.
Yeah.
And he paid it. For the next hearing, his hearing was allowed only upon subject to payment. And then of course, I dismissed the appeal as not involving the question of law at all. And then the money was used for legal service authorities, for poor litigants and all that. So that's a different matter. But what I feel, sir, I have been feeling like a judge and lawyer for the last 40 years, that government being the main litigant in our country, our system, needs a great reform, and things or procedures have to be streamlined there. Why repetitive appeals? Why endlessly appeals? Somewhere they should introduce the finality to the judgment, even of a district judge also.
Good.
There is no need to take every matter to the Supreme Court.
Thank you. Thank you so much.
Thank you so much.
Thank you, everyone. We're hunting for 51 points to write to the law minister. Today on my sheet, I have 21 points, which means I need for all of you to think about this topic and send us more points. Talk to your friends and ask them a point each, and send me more points so we can get to 51. And if not, we'll do another session with a new panel and keep doing this. Thank you so much, all of you. Hope you have a wonderful day, rest of the day.